Hello. So this on your screen, ladies and gentlemen, is the preamble of the longest written constitution of the world. That is the Constitution of India. Well, I'm sure you must have read it before as well. But now if you look at it very carefully, you will find that there are a few words like democratic, republic, socialist and secular which have been written in bold and capital letters. Now what we are discussing today is, can the words socialist and secular be removed from this preamble? In fact, the question is, should these words be removed from this preamble? Now, this is not the very first time that this debate has caught attention. There have been multiple instances before as well when it has been in the news. In fact, the very first instance of this debate about the inclusion of the words secular and socialist in the preamble comes even before the preamble was commenced. Back in 1948, in the Constituent Assembly, when the design of the Constitution was being discussed among the intellectuals, there's this very famous debate that we read between K.T. Shah, the Bihar economist, and the father of Constitution, Dr. Bhimrao Ambedkar. Now, in this debate, K.T. Shah proposes that the words secular and socialist should both be included in the preamble of the Constitution. Opposing to which, Dr. Bhimrao Ambedkar said that the fundamental rights of our Constitution themselves make our Constitution a secular as well as a socialist one. So, including the words socialist and secular in the preamble of the Constitution would kind be of a superfluous, in the words of Dr. Bhimrao Ambedkar. So it was decided that these words, socialist and secular, are not going to be added in the preamble of the Constitution. But later in 1976, when Srimati Indira Gandhi was the Prime Minister of India, 42nd Amendment Act was introduced and both the words, socialist as well as secular, were added in the Constitution, in fact the preamble of the Constitution of the country. Now this time, a PIL, public interest litigation, has been filed by a BJP leader who is named as Subramaniam Swamy. This PIL is seeking to delete the words secular and socialist from the preamble of the Constitution. Subramaniam Swamy, in front of the Supreme Court bench, said that because these two words were included through 42nd Amendment Act, which was introduced in the period of emergency, that is in 1976. So these words should be removed from the preamble of the Constitution. Responding to which, Supreme Court had said a few things which are very interesting. But before we move on to what the Supreme Court said, let us first understand what is the meaning of these two words, secular and socialist. Now, if we talk about the word secular, secular literally means that the state has no religion, which means the state will not favor any religion. Person of every religion in this country will be availed equal rights and opportunities to upgrade their lifestyle. As far as socialist is concerned, socialist is a word which depicts the social organization of the society, which precisely means that an economic system where the government has equal and necessary intervention. The market is not controlled by the individuals for their welfare, but the government ensures the welfare of each and every individual in the society and the market. Now coming back to if the words socialist and secular can be removed from the preamble of the Constitution of the country, there are certain judgments we need to refer to understand if this can be done or not. Also, you may wonder that what will be the procedure to make these changes. There's a very simple procedure. The government has the rights to amend the Constitution. Article 368 of the Constitution gives this right to the government that you bring an amendment to the table, get it passed from the parliament, and then you can make the required changes in the Constitution as well. Article 368 gives you the power. But with these powers of amendment, making amendments to the Constitution, there are some restrictions as well. I'll tell you about the Kesananda Bharti versus State of Kerala, landmark judgment ever in the history of the independent judiciary system of the country. The 13 judges bench was constituted. It is the largest bench ever in the history of the independent judicial system of the country. So in the State of Kerala versus Kesananda Bharti judgment, Supreme Court made some very important observations. The very first observation was that the preamble itself is a part of the Constitution. Therefore, the Parliament has every right to amend the preamble, which we saw earlier as well. In 1976, Srimati Indira Gandhi made the amendment in the parliament, in the preamble itself. So that's not an issue. But here comes another observation from the Supreme Court, that with the rights, with the powers of amending the Constitution, there are certain restrictions. Any amendment which somehow voids the basic structure of the Constitution of India will be declared unconstitutional. Now, what is this basic structure of the Constitution? There were certain terms that were defined in this basic structure of the Constitution in this judgment of Kesananda Bharti versus State of Kerala. And this definition of basic structure of the constitution was given by all the judges separately. Now, the answer to the question, if these words can be removed, or does the parliament have the power to remove these words? Yes, the parliament has the power to remove these words. The parliament has the power to amend the preamble as well. But it does not have the power to amend the basic structure of the constitution of the India. That is what the landmark judgment and the Supreme Court said in the Kesananda Bharti versus State of Kerala case. This is it for this video. I'll see you in some other video. Till then, take care of yourself. Thank you so much for watching this video. Take care. Bye-bye.